Okay, looks like we are in. Hi everybody, welcome to today's session of UPSC Buffet by Gallant IAS. Since the last week we have been discussing things on a general level, mostly discussing the outlier topics, occasionally cutting across the economy, polity part of things. But from today onwards, we'll be dealing with we will be dealing subject wise and topic wise. And first of all, the plan is to go with the PYQs. I'll be taking past 5 years PYQ and we'll analyze all the questions from that particular part. Actually, today we'll be discussing the polity side of things from the 2021 prelims paper. So I have taken the questions and I'll tell you how to answer those questions, how to think in order to solve those polity questions, and the kind of knowledge you need to have so as to eliminate things or arrive at an answer more easily and be more confident with your answers. That's one thing. Then another thing is that since you are once your fundamentals are done with the PCM courses, you will be focusing more on studying now, mostly learning the concepts for the exam point of view. So this is the best time to tweak your studies in a way that it suits the demand of the examination. It's not a wise strategy nor the right strategy to go and read the books cover by cover, whether it's Lakshmikant or NCERT or any book that you are referring to. Don't go cover to cover. Just focus on the areas that are maximum reward, that gives you the maximum reward. Focus on them and go through the PYQ and analyze the trend. Here way you can reduce the number of mistakes and you can get more mark out of polity. The good thing about polity is that once you are set with the basics, there is a good chance that very little questions will come out of the syllabus kind of level, and out of the box questions will be very less. And polity being a core part of your syllabus, and you are guaranteed to get at least 15 to 20 questions. In the past, the trends have changed about all the subjects for history, geography, etc. But the polity and economy have remained very constant with their constant share of questions. So it's a very rewarding thing. Stick to that. Polity can get slightly complicated, slightly, that can lean towards borderline rote learning because we need to remember a lot of things. But go with a structured approach, which I will help you, and try to do things the way I tell you to do, as in the way, the thought process and the studies. Try to arrange it in such a way. It can really help. If you are following your own strategy, go for it. But to those who are lost or planning to do something, follow this strategy. This works very well for most of the aspirants, and this works for me as well. So I won't be going content heavy on the questions or topics. It's all about the conceptual understanding you need to have, and I'll be giving small task for the day or takeaways so that you can look into it and learn things more clearly, so that you can actually apply these questions and practice your knowledge level in the test series and actually clear the exam, and at least the polity part of things very clearly. Once you clear the polity things, it's almost certain that you can make it to the list. That's very sure. So this has got a rewarding position on prelims and mains as well. So let's get started. Okay, right off the bat, questions in Mumbai, I'll tell you a few things. These are the kind of things you need to know. Okay, these are the basic. I have just crystallized the entire polity syllabus into these headers. They may, depending on the way you look, they may look like, okay, they are heavy or they are too much, or the way you look, they are crystallized. Actually, they are very much in a crystallized format. This is as small as it gets when it comes to polity. You need to have an idea about all of these things. But prioritization matters. You don't need to study. You are not supposed to give equal weightage, equal effort, equal time for salient features of the constitution and compared to fundamental rights or DPSP. Right away, start your preparation with preamble, fundamental rights, fundamental duties, DPSP. This should be your bedrock. These 4 portions, these 4 topics are gonna get you immense reward in the examination. Make them very solid, learn them, and learn them in such a way that just don't simply by heart them. Learn them through questions, especially PYQs. And since we don't have too much PYQs, try to go through the entire PYQ regarding these portions: fundamental rights, fundamental duties, preamble, and DPSPs. I would say these are the four key areas that can really level up your polity answers as in clearing your examination also. So I hope you understand the necessity of that. So Stick to that. You can take a screenshot, or I'll be sharing this in the Telegram channel after the session. So that's it. Let's get started. Right off the bat, since we are discussing 2021 prelims, we'll be discussing few things like most of these topics are covered in 21 also. The spread of questions are there. It's spread across, all polity questions, or every year we'll be having questions from these portions with more questions from preamble, fundamental rights, DPSP and fundamental duties. At least one or two each. That alone makes it some 80 to 10 questions. So it's very rewarding. Don't skip that part, and don't make the mistake of just by hearting them and putting the effort in a wrong way. Put your effort in the right way possible, so that you can get the maximum efficiency and you don't tire yourself out. Polity need not be a daunting topic. You don't need to know everything about it. You just need to have the knowledge to mark the right answer, choose the right answer, or eliminate the wrong ones. That's it. It's as simple as that. Don't overcomplicate it. Okay, so that's it. Let's start. First one. Which one of the following in Indian polity is an essential feature that indicates federal character? Okay. So that's the question. Just a second. Okay. It's an essential feature. Okay. That's a very important keyword. Underline it. There is no way around it. Underline it. Don't make the mistake. Federal character. So which one of the following in Indian polity is an essential feature that indicates that it is that it is federal in character? Okay. So we know our Indian polity, is it a federal is it truly federal or is it truly unitary? It's questionable, right? We say it's a quasi-federal polity we are having, and KC Ware and all sort of political strategists have said that India is a unitary state with some core federal features. At the same time, the federal characteristics are part of the basic structure also. Sometimes you might think that, okay, since basic structure has got federal features, India is truly federal. No, India is not truly federal. There are a lot of features like emergency, the central list and overriding powers of parliament, state emergency, the president's role. Everything indicates that India is ultimately a unitary state, but with some core federal traits. That should be in your mind. Okay. The first option is independence of judiciary is safeguarded. Yeah, having an independent judiciary really adds to the federal character of the nation. Yeah, yes. Union legislature has elected representatives from constituent units, meaning that they have representative from states. Okay, that is a federal, that has got a federal character to it, and that is also followed in the Indian polity. That is there. Union cabinet can have elected representatives from regional party. This is entirely political. And entirely political also, it has got a federal practical application when it comes to federalism, because having regional parties actually bolsters the federalism. This is something that you write in answers in mains, but the question is a bit theoretical in nature. The fundamental rights are enforceable by courts of law. Okay, fundamental rights doesn't necessarily have any sort of relation with federalism, as in they do have when you look deeper, but right off the bat, these days, considering A, B, C, this thing is definitely not going to be a reason. So, you can eliminate that. Fundamental rights are enforceable by law. That's not something that is directly related to federalism. So, that's the first thing we are eliminating. Then, Union legislature has elected representative from constituent units. That's good. Then, that's a good part. Then, the Union cabinet can have elected representatives from regional parties. It is saying that can have elected representatives from regional parties. It's asking an essential feature, and at the same time, it can have representative. These two statements seems very similar. If one is not there, then the other one should also be not there. So this is not a very likely thing, because it has given can and essential feature. So this is not the right thing. Then next up, Union legislature has elected representative from constituent unit. Yeah, of course, it kind of adds to the federal nature, but is it really the essential feature that makes India federal, like the federal character of India? Not really. Independence of judiciary. How is this federal? How this upholds federal character? Because imagine a judicial system where judiciary is ultimately, or the separation of powers between judiciary and legislature and the executive happens only at the central level, and the judiciary is not independent. For example, in the case of USA also, the independence of judiciary is questionable. Because they have got appointments are made by the president, things like that. Here also appointments are made by the president, but we do have a collegiate system, and the judiciary is independent. By the constitutional nature of the country, it's independent. And this independence ensures that the federal nature or the federal character of the constitution remains intact, irrespective of the political changes that are happening. So, that's how judiciary is related to federalism. Because having an independent judiciary, meaning separation of powers and checks and balances, ensures that federal character, which is a basic part of our constitution, is safeguarded. So this is the answer. These two things are the practical political side of things. They are true. I'm not saying this is false or anything, but this is the essential feature that indicates the federal character of our Indian polity. So this is the answer. The key takeaway is features that make India, first of all, federal, then unitary. You need to know both. Sometimes it can get confusing, and sometimes certain features make you think that okay, this makes it federal or this makes it unitary, which in reality will be the other way around. So have an idea about the features that make India federal and the features that make India unitary. As I have mentioned, the unitary features like the president's rule, emergency, overriding powers of parliament, financial emergency, things like that are all unitary features. At the same time, federal features are like basic structure of doctrine. Basic structure doctrine has got federal features as it's mentioning, and there is two houses and there is a council of states, that's Rajya Sabha. These are all federal features. There are a lot of federal features. Go through them, understand the crux of it. Don't just by heart them. If you by heart them, the question will be theoretical and you won't be able to apply it. Just learn them in a way that you can feel it, that okay, this makes India federal, this makes India unitary. But at the end of the day, you need to know that India is not a federal state, truly federal, and not truly unitary as well. It's a quasi-federal state. But at the same time, it's not a 50-50 division between unitary and federal. It's mostly a 70-30 division. It's 70% unitary and 30% federal. So that's it. Moving on. Next question. Citizenship. I think since it's Article 1, you're starting off with the Article 1 and you will be going through the first page of Lakshmikant, you will be stuck in citizenship, where there is a lot of criteria mentioned and there is a lot of complications out there, and you will be spending so much time writing notes and all. I'll tell you a few things. Citizenship part is not very rewarding. You can get at max one question. More than that, it's not possible, and it's not asked every year also. So don't spend too much time in studying citizenship. Just have an idea, okay, who all can be citizens and what are the things in place, like the overseas citizen of India, and is there dual citizenship, and what are the reasons for annulling one's citizenship, and these things like that you need to know. And also the basic criteria for being an Indian citizen, based on the dates they have mentioned. Have an idea about that. Even for me, those dates and those criteria can get confusing. Just make a table, write about it and leave it. Just go through it once in a while. Don't spend too much time reading Lakshmikant and finding every details about it. It's not really necessary. Having the bigger picture here really helps, because while I was attending this question in the real examination, I absolutely had no clue about those particular criteria about citizenship, because I couldn't study it. I didn't have the time for that. But I managed to mark this question right. I'll tell you how. First of all, there is only one citizenship and one domicile. Okay, that is there because India has got only one citizenship and one domicile. But again, I was a bit skeptical because of I wasn't very sure about the OCI card holder thing. So I was a bit skeptical about this statement. I couldn't eliminate it or choose it right away. A citizen by birth only can become the head of the state. Actually, this is not the case. Since the partition has happened and a lot of its diversity of India is there, and we are not very much in line with the approach of sons of soil theory. That's like there are two basic theories for citizenship. It's called jus soli and jus sanguinis. Jus soli means based on place of birth. Just sanguine means relation through blood, as in a person can become a citizen when they have a blood relation, as in if their parents are citizens of the country, they can become citizen. The same way, if somebody is born in India and with certain conditions, they can also be granted citizenship. There are countries which follow this jus soli principle, as in USA also. That's the best example. A citizen by birth only can become a head of the state in USA, not in India. Anybody who is a citizen can become head of the state. Head of the state, as in, it's talking about president. So even for president, minister, or anybody, we know that criteria that are mentioned. There are only very few criteria. I think only 2 criteria are explicitly mentioned in the constitution. Be a citizen of India and 35 years of age. That's it. It doesn't mention one should be based on, they should be born in India at the time of citizenship or anything of that sort is not mentioned. But in USA, it is there. A naturalized citizen cannot become the head of the state in USA. So that's jus soli and jus sanguinis. These are the 2 criteria or 2 approaches to citizenship. So 2 is wrong. Gone. So obviously 1 is right. A foreigner once granted the citizenship cannot be deprived of it under any circumstances. How is that even relevant here? Anybody or anyone's citizenship can be revoked. There are explicit conditions and giving power to the parliament and the executive to revoke the citizenship based on certain conditions. Disrespect to the national integrity, things like that. And also a foreigner once granted citizenship, and if they acquire a citizenship from other place, India doesn't have a dual citizenship. So basically their Indian citizenship ends there. So this is obviously wrong. So 3 is wrong, 2 is wrong. And we arrive at the answer as A. So I hope it's clear. This is all you need to know. See, the question of citizenship came. People who might have read everything about it might not be able to solve this thing because they might have missed that. Okay, citizen by birth only can become. They might have got stuck in that. The third statement is a bit extreme and you can eliminate it. So this is where I said understand things conceptually rather than just mugging them up. Mugging them up can really, reduce your focus area, and it can give you a tunnel vision of sorts where you need actual vision. Like you need to have a peripheral vision about the question and about the backdrop of things happening. So that's why I'm saying learn things in a way that you should be able to solve questions, not become knowledgeable, or that's not the primary thing. Being knowledgeable is different and being able to solve question is different. Don't confuse it, because I know a lot of people who are very knowledgeable and they fail to mark the questions right, because the knowledge can sometimes backbite you. So be mindful of that. That's it. Move on. Next question. Constitutional government means. We have discussed this in the past week. Those who follow, they will be knowing the answer right away. Constitutional government means a government with a constitution, and the core nature of a constitution is that it's written or it is codified. It's not necessarily written per se, but it has got some codifications, and this codification ensures that the government is limited, or the power or any action government can take, or the legislature for that matter can take, is limited by the constitution, because it's like a law. So nothing can go beyond the law. Law sets the limits. The same way constitution sets the limit, the upper limit for everything. So anything happens inside that. Okay, so it's like a fence. Constitutional government is like a fence to protect the people in from within and to ensure that the ones inside doesn't cross the limit, the judicial limit or the legislative limit or the jurisdictional limits. So a constitutional government means representative government of nation with federal structure. This is a federal government, a government whose head enjoys nominal powers. This is parliamentary form of government, I guess. A government whose head enjoys nominal powers. Same way with India, it's a parliamentary form of government. A government whose head enjoys real powers. This is like a presidential form of or executive government. This is no. A government limited by the terms of constitution. This is the right answer. Also, there is a way to approach it logically. Think about it. A government whose head enjoys nominal powers. How is this related to constitution? Because if you have a constitution, it can mean the head enjoys real or nominal powers. For example, in India, we have a constitution where the head enjoys nominal powers, that the president is having a nominal power. So that is there. We have a constitution. This could be right if you look at that like that. Okay, a government whose head enjoys real powers. The case of USA. USA also has got a constitution. So these both cannot be right. So that's one way you can eliminate both. And a representative government of a nation with federal structure. Not really necessary, because a constitutional government can have a non-federal structure. It doesn't necessarily need to have a federal structure. So that's also gone, and we can arrive at the answer logically. But constitutional government means once that is limited by the terms of constitution. It's very plain and simple. Just understand that. And similar questions have been asked after this 2021 question in different forms. But just having this idea will really help you. And getting one question like this and instantly marking it, you can save a lot of time and can increase your chances of clearing it. So just learn about I think there is not much takeaway, but just learn what's a constitutional government and other forms of government. Parliamentary, executive, presidential form, and constitutional monarchy. Examples also. Examples for all of these. Having an idea really helps. Think about it, compare it, and you can just arrive at the answer. This is the takeaway. Moving on. What is the position of right to property in India? Okay. This is kind of the favorite part of UPSC. This question has been asked in the past multiple times in multiple formats. What is the position of right to property in India? Okay, we know right to property. When you hear that, it's somebody who doesn't really know much about the 1978 44th Amendment, things like that. They or not having an idea about the fundamental rights. They think that, okay, right to property in India seems like a fundamental right, because mentioning the wording is exactly similar to right to privacy, right to freedom of speech and expression, right to life. It sounds exactly like that, and those are fundamental rights. So there is a chance that this could be fundamental right. I'm saying about people who really don't know it, but that's not the case. This is one very big exception when it comes to fundamental right, because right to property initially was a fundamental right. And with subsequent amendments, starting from the first amendment, it was diluted. That government can take necessary measures by due process of law. Government can actually restrict the right to property or take away property, because see, the land reforms, when the land reforms are implemented, people can just right away argue in the court saying that it's right to property, or it's my right to property. Consider other expansion process also. If government is acquiring property for constructing a road, bridge, or things like that, this can violate right to property if it's a fundamental right. And fundamental rights and those petitions can go a long way, and this can stall the developmental process and overall economical growth of the country. And also it can challenge a lot of welfare measures that government are putting in. So this is not really a practical thing to implement in terms as a fundamental right. So it's not a fundamental right, first of all. Fundamental rights available to citizen only. It's neither a fundamental right nor a legal right. This is where having the knowledge comes into the picture. Article 300A states that it's right to property. It's a constitutional right, actually. But here, constitutional right is not mentioned explicitly. But in the later UPSC answers, it was mentioned as constitutional right. So if you come across an option where they have mentioned legal right and constitutional right, the question is, what's the position of right to property? And we have got two options, constitutional right and legal right. Go for constitutional right, because it has got a constitutional mentioning and it has got a higher standing when compared to a normal legal right. So Article 300A, constitutional right, that's the thing. But here constitutional right is not given. So we have to choose between the legal right. Which form of legal right is there? Legal right available to citizen only. This is something that you might think, when you think logically, this can go wrong also, because okay, thinking about right to the property, it's available only to citizens, right? This should be like that. But the issue is, think about a foreign entity, foreign company setting up their plants or setting up their offices here. Don't they have the right to the property? Of course they do. Then only things can work like that. So it's a legal right available to any person. It's not limited to citizens only. So this is wrong. And this is right. There are few takeaways from this question actually. You need to know rights, fundamental rights available to citizens only. There are 15, 16, 19, 29 and 30. Learn more about that. As in, what are they, and have an idea about that. This really helps in eliminating the options. So you should be very clear about the fundamental rights that are available only to citizen. Those are 15, 16, 19, 29 and 30. Learn more about that, okay? So that's one thing. And then, yeah, that's about it. That's the takeaway. This is very important, okay? Make sure you cover this. This is really important. And learn about this constitutional right. And also, since 44th Amendment is connected to that, you need to learn about 44th Amendment of 1978. So that's also needed. Because 44th Amendment, Janata Sarkar, they are the ones who made this, completely changed the nature of the, right to property and made it a constitutional right. It can be said that it's a legal right. If in the options it's no constitutional right is mentioned, you can go for legal right. If constitutional right is mentioned, go for it. Because UPSC in the later answers, they have given it as constitutional right only. Okay, moving on. Next question. Under the Indian Constitution, concentration of wealth violates. Very important. Under the Indian Constitution, you have to look at the thing, concentration of wealth phenomena within the lens of Constitution, not your general logic, not your general idea of welfare, not your general idea of governance. Okay. So concentration of wealth violates right to equality. Okay. On first look, you might think that, okay, it can violate because some people getting too rich and other people getting too poor. Will it be violative of right to equality? Yeah, it can be, but at the same time, there is free will. Okay, we are not a hardcore communist or socialistic state. We have got significant personal freedom and we don't work like that. Of course, there is an element of socialism in our entire policy making, but it doesn't really violate right to equality. Because if you know what's right to equality, you can really understand that concentration of wealth has got no connection to it. Right to equality means equality before law. The person will be treated irrespective of their background, and the government will be treating them fairly irrespective of their background, and they can have equal rights. That's the only thing. Everybody is equal in front of the law. That's it. And one important thing is there is equality before law and equal protection of law. This is another important topic. Versus equal protection of law. This is proper Westminster model. As in, it's basically rule of law thing. Law applies equally to everybody. But at the same time, equal protection of law is bit more nuanced and justice oriented, because they'll be treating equals will be treated equally and unequals won't be treated equally. That's the basic rule of equal protection of law. It's more affirmative and positive in nature. On the other hand, equality before law is negative in nature, as in it's very straightforward. There's no nuance to it. Everybody will be treated equally. And you might have heard about the Ambedkar's quote that equal treatment of unequals is as bad as unequal treatments of equals. So equal protection of law addresses that issue. So just learn about these differences between these. These philosophical questions will be coming in prelims, and they'll be coming in multiple questions also in multiple formats. So having an idea really helps. So concentration of wealth violates right to equality, no. Directive principles of state policy. This is where having the knowledge really helps, because explicitly mentioned in 39B, it's explicitly mentioned that concentration of wealth state should take affirmative action to prevent the concentration of wealth. I'm not saying the verbatim thing because I couldn't remember the exact DPSP, but I just have the idea that it is mentioned in the DPSP under 39. So that's there. So I know by fact that this is the right answer. But also we can think about it in a more logical way. Right to freedom. How is right to freedom violate concentration of wealth? Because if somebody is concentrating wealth by legal legitimate means, it's their right to freedom. So it doesn't really violate any right to freedom. So that is there. Concept of welfare. Okay, this can have an issue. This of course have an issue. That's why it's part of the directive principles of state policy. This is true actually. This is not wrong. But in the Indian Constitution, DPSP is explicitly mentioned in DPSP. So in questions where there is an explicit mention of mentioning of DPSP, or things mentioned in DPSP are there, and something related to that is also there, go for the ones with the direct mentioning. As in, if that's directly mentioned in DPSPs, just choose it. This is where having that knowledge really helps. If you didn't know that in DPSP, such concentration of wealth or something like that is mentioned, you might think that, okay, concept of welfare is right, and you might mark it, and this can go wrong. So that is where you need some level of knowledge. As always, I said, learn DPSPs. Okay, make notes and learn the articles. Very important. Okay, this is going to be the hardest part of polity, the DPSPs, because from 36 they have got the entire part 4 of the constitution from 36 to 51, and the classifications are there. Also remember one thing, the classification as liberal, liberal intellectual, Gandhian, those sort of classifications are not mentioned in constitution. It's just, I think it's just for the sake of studying. I don't think I think it's a product of Lakshmikant's brainchild, if I am not wrong. So those classifications are not mentioned in the constitution. Be very clear about that. Okay, constitution doesn't classify anything. It doesn't mention any Gandhian socialism, liberal intellectual or anything like that. So be very clear about that. Such things are not mentioned in the constitution. It's just those classifications are made for the ease of study. That's it. So we get the answer as DPSP. Moving on, next question. Which one of the following factors constitutes the best safeguard of liberty in a liberal democracy? Okay, so they are asking which of the following arrangement or the following principles can ensure that the liberty is best safeguarded in a liberal democracy. Okay, a committed judiciary. On the first reading, you might think that a committed judiciary meaning that once that's committed for the sake of or the cause of people, but committed judiciary by definition is one that's committed to the government. So that's not the case. Then centralization of power. Obviously, centralization of powers is negative in all aspects. We are very well against that, and centralization of powers is one thing that the government or not government, the constitution and the makers of the constitution struggle so hard not to have. So centralization is definitely not there, but of course, centralization happens because we are a diverse country. We needed centralization, but at the same time, centralization of powers can have it's mostly in a negative connotation. So this definitely can't be right. This is absolutely wrong. Elected government. Okay, elected government can safeguard, but think about it. There are elected government across the world. Are they able to safeguard the liberty of their people? Not really. So elected government is not really a case. It depends on the elected government. Separation of powers. This is where things get, serious. Because separating the organs of government into judiciary, executive and legislature, it ensures that liberty is maintained. What is liberty? Ability of oneself to develop fully. That's liberty in its textbook definition. And having separation of powers ensures that all the organs are operating within their limits and not overstepping and not leading to tyranny. So the liberty is safeguarded. So that's one thing. And separation of powers in all aspects is a very positive thing. Just the opposite of centralization of powers. Separation of powers is a very positive thing. So in most answers, if separation of powers is there and you can't find any other thing that comes close to it, this would be an answer that is there. And committed judiciary is there, but this is not something necessarily guarantees liberty in a liberal democracy. An independent judiciary actually can. Having an independent judiciary, if the question was like that, then it's there. But at the same time, if there also separation of powers is there, this is more accurate. So go for separation of powers. That's it. Learn about separation of powers. Okay. Actually, in DPSP, I think it's 51, I guess. 50 or 51. I don't remember exactly. There is separation of powers mentioned. So be aware of that it is explicitly mentioned in DPSP, and the same question has been asked in the past also. I don't remember exactly the article 50, I guess. So that's it. Then moving on, next question. At the national level, which ministry is the nodal agency to ensure effective implementation of the Scheduled Tribes and Other Traditional Forest Dwellers Act, FRA? It's Forest Right Act 2006. Okay. This is a slightly tricky question. You might have come across few of these legislations like Forest Right Act. Then we have got one more thing, Forest Right Act, and Grama Sabha, minor forest produce, things like that. Everything under that comes under this Forest Right Act. So these sort of legislations, CAMBA Act, these sort of legislations are important. These are the ones that are been, you can apply that in polity and environment. So have an idea about that. So there are few legislations like that. I have mentioned that in the checklist. Go through that for more details. So just analyze this question. It's not something that everybody will be knowing. So don't think that if you don't know this, you are not doing it right. This is slightly on the trickier side for some people. Even for me also, it was slightly tricky because I didn't know exactly what this was, and I didn't go through the Forest Right Act portion. I just knew such an act existed, and this minor forest produce and things like that were there. That's all idea I had, but somebody who knew it will be able to answer it, and I think most of you will know it. Even if you don't know, don't worry. We will be having some sort of missing here and there. It's perfectly fine. Anyways, solving the question. Forest Rights Act. Okay. Ministry of Environment, Forest and Climate Change. Okay. This is a plausible ministry because they are the ones dealing with forest and management of forest, things like that. So it's plausible. Okay. Ministry of Panchayati Raj. Chances are very less. Of course, Grama Sabha is involved, but Ministry of Panchayati Raj, they are mostly dealing with the rural development or things like that. Ministry of Rural Development, not really, because their entire focus is different. Ministry of Tribal Affairs. Again, when you think about Ministry of Tribal Affairs, we might think that, okay, protection of tribals, and then, formulating policies for their protection, things like that. That's exactly what this Forest Right Act is all about. It's protecting the tribal interest, or protecting their tribal interest, and protecting their culture, protecting their livelihood, etc. So this is a very plausible scenario, and this is also having a higher chance. So here, choosing between both, go through the question again. It's mentioned Scheduled Tribes and Other Traditional Forest Dwellers. So it's explicitly mentioning Scheduled Tribes. And so since an explicit mention of Scheduled Tribes are there, it's a very good chance that Ministry of Tribal Affairs will be the answer. Okay. Ministry of Environment, Forest, Climate Change is a good, it's a possible thing, but compared to Tribal Affairs, and we have got a mentioning of Scheduled Tribes, this is going to be a more accurate answer, and in this case, it's the right answer. So Ministry of Tribal Affairs. Just develop a logic, or just have an idea about questions like these and ministries. I think in the last week also, I told you about learning about ministries, especially the confusing one. Ministries. And bodies attached to these ministries. The confusing ones are actually Ministry of Commerce, Ministry of Agriculture, Ministry of Finance, Ministry of Environment, Forest, Climate Change, Ministry of Earth Sciences. Because Geological Survey of India and those sort of things comes under Ministry of Earth Sciences. So these are the things you need to know, and major bodies attached to these ministries. And if you come across any body, for example ISRO or SEBI, or I think NAFED, TRIFED, things like that. If you come across any body, just immediately search this body comes under which ministry and have an idea about that. Just lock it in your brain. It really helps, because having an idea about ministry can help you solve a lot of questions, and I think UPSC is slowly moving into that trend also. They will be asking more questions about that in the coming years. There's a good chance for that, because UPSC is focusing more on the practical side of things, and if you are very well aware about the ministries and their their mandates, it kind of makes you a better better candidate for being a civil servant. So things like that are getting more and more important these years. So pay attention to this. Learn about the bodies attached to these ministries. I mean, don't go through their website and learn about all the ministry. No, that's not you should be doing. You should know some, for example, National Groundwater Authority belonging to which, under which ministry and under which act, things like that you need to know. Bodies and acts, their respective acts, as in whether it's for statutory bodies. That's how you should be dealing with it. And not just statutory bodies, there are some constitutional bodies under some certain ministries, so you need to know about that also. That's it. Moving on, we adopted parliamentary democracy based on British model, but how does our model differ from that model? This is Polity 101. I think this is the first thing you will be learning in your polity classes if you have attended a PCM session. So you might know the answer right away. As regards legislation, the British Parliament is supreme or sovereign, but in India, the power of Parliament to legislate is limited. Yes. The parliamentary nature of both countries are different, because here Parliament is sovereign but not supreme. Our Parliament is sovereign but not supreme, because and people think that there is a judicial supremacy is practiced. No, we have a constitutional supremacy. The judiciary is just the interpreter. So in practice, judiciary has got an upper hand when it comes to legislations or annulling the legislations. But in principle, it's constitutional supremacy. So in short, British Parliament has got parliamentary supremacy. On the other hand, Indian Parliament has got constitutional supremacy. We are limited by the Constitution and its basic structure. So one is right. Supreme in India, power of Parliament to legislate is limited. Why? Because we have judicial review and basic structure doctrine. That's it. In India, matters related to constitutionality of amendment of an act of Parliament are referred to the constitutional bench by the Supreme Court. These two statements are actually connected. If first is right, then two is also right. So, or if such a thing is not right, then the other one is also not right. So they are both connected, and answer is C. So judicial review, related articles, that is article 13, I think 13, 32 to 26, they're all coming under judicial review. Then one more thing you need to know about is judicial review and sovereign parliament. Okay. From this question, judicial review. Okay. I think for now, just learn more basic structure doctrine. That's it. Basic structure doctrine. Cases related to that and features mentioned. For example, secularism, federalism, those are all part of the basic structure doctrine. And cases like Keshwananda Bharati case, Vaman Rao case, Quixote Holohan case, and in the latest one, IR Kolo case, they have all got some sort of mentioning to the basic structure doctrine. So you need to know about that. Features mentioned. Which all features are there? Also, you need to have an idea whether this basic structure doctrine is very much codified. It's very explicit or not. No, it's not very explicit. The courts have not clearly defined what it is. So it has its own goods and bads, because not defining it can cause arbitrariness. But at the same time, not defining it can actually make the constitution or the value of the basic structure doctrine more adaptive and dynamic to the demands of the time. So that's the thing. So anything that's not codified has got the advantage and disadvantage. If it's codified, it's static. If it's not codified, it has got the problem of being arbitrary. Have these ideas in your mind. Think about the polity, political flaws, everything in such a way that you can just feel it and you can, internalize it rather than just learning it what it is. Just think about it. So these are the few things. Then right to privacy, UPSC's favorite. Every year there will be at least one question from regarding right to privacy, right to life, right to marry someone you like as in consensual marriage, things like that are there. So there will be this right to privacy, which is always there. So Article 15, right against discrimination. Article 19, right to freedom of speech and expression. Article 21, right to life and liberty. Article 29, minority rights to cultural and educational rights. So cultural and educational rights definitely gone. Right against discrimination, no. Right to freedom of speech and expression, right to life. Right to privacy is more related to right to life only. So it's Article 21. Article 19 and 21. Some of the provisions can get little confusing. So go deep into that, learn about it. Okay, compare 19 and 21 and just have an idea, because Things like I think protection against phone tapping is mentioned in Article 19. So that is there. Then right to information belonging to which article, you need to know about that. So learn fundamental rights thoroughly, and be sure about articles as in 14 to 18 right to equality, then 19 to 22 right to freedom, things like that. You need to categorize these articles from 14 to 32. You need to categorize it, okay? And 14 to 32, you need to categorize it based on this right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights. Those kind of things you need to have an idea, because UPSC has explicitly asked Article 17, right against untouchability comes under which article. If you have an idea that it's under right to equality and if Article 17 is there, you can choose it. So learning it like this really helps. So start off by structuring or dividing articles based on these broad categories, like 14 to 18 right to equality, 19 to 22 right to freedom, 23 and 24 right against exploitation, things like that. First classify them, then under that header learn what all the specific entries are made. So learn, first have a broad idea, then slowly zoom in, and then use questions to remember them. You can easily get questions. You can use ChatGPT, or better, you can use the test series. Gallant test series is actually good. I'll be adding some questions from there also, so that you can practice and follow the Gallant channel. It's really helpful. Questions have got a really good UPSC outlook to it. You can follow that also. So that's it. Then next question. Judicial custody means the accused is in custody of the concerned magistrate, and such accused is locked up in a police station, not in a jail. Okay. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. This is where UPSC is testing you whether you know the basic law and order or criminal justice system of India. What is usually passed. Somebody who is not very aware, because this is not something that you learn right away. Of course, we have a mentioning in fundamental rights, like right against arrest and detention, things like that are mentioned. So you come across these kind of things, but this exact police station jail thing, you might miss it. So just have an idea that this is how it works. I think most of you might have seen the movie Ayappan Goshim. പൃഥ്വിരാജിൻ്റെ കേസിലെ പൃഥ്വിരാജിൻ്റെ ഇതേപോലെ ജാമ്യം കിട്ടാത്ത വകുപ്പെന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ എന്താണ്, മജിസ്ട്രേറ്റ് വോണ്ട് ഗീവ് ബെയിൽ, ഹിൽ ബി ഡയറക്ട്ലി റിമാൻഡഡ്, ആൻഡ് വെയർ ഹി ഗോസ് നോട്ട് ഇൻ എ ലോക്കപ്പ്, ജയിലിലേക്കാണ് പോകുന്നത്. സോ ഹാവിങ് ദാറ്റ് ഐഡിയ ഓൾസോ റിയലി ഹെൽപ്സ് if you are not very aware of things. So judicial custody means that if magistrate is giving them bail, they won't end up in remand. They won't be remanded. Remanded means they'll be sent to the sub jail or whatever jail the magistrate says. So it's not locked up in police station. It's a temporary thing. They are not going into the lockup or anything. They are going to the jail only. That's called being remanded. So this is wrong. During judicial custody, police officer in charge of the case is not allowed to interrogate suspect without approval of court. Yeah, that is true. Once they are in the judicial custody, police need to have the permission, take the permission to interrogate them. Yeah, that's true. So B is right. So 82B. There is no particular takeaway from this, but learning, right against arrest and detention, and also one more thing is there. Basically that's it. Then criminal justice system, having an idea about that helps. Justice system, how crimes are recorded, what's an FIR, and how is it filed. It's not very rewarding, but it helps. It helps in solving some questions, and also it helps you become more aware about the political or the criminal justice system that is out there. And so especially in the backdrop of these new legal codes like Bharatiya Nagarik Suraksha Sanhita, Bharatiya Nyaya Sanhita, Bharatiya Sakshya Bill, these sort of Sakshya Sanhita, these sort of things really helps. Having an idea about all of this really helps, write answers, and sometimes questions might come up, but don't spend too much time on that. Don't ever try reading Bharatiya Nagarik Suraksha Sanhita or anything unless certain provisions are mentioned, some controversial provisions are mentioned, some good provisions are added. Just remember about that. That's it. Okay, next one. Montagu-Chelmsford reforms of 1919 recommended granting voting rights to all the women above the age of 21. Yeah. Okay, Government of India Act 1935 gave women reserved seats in legislature. First of all, it's an extreme statement, and you can imagine the year 1919. There was no universal suffrage for India until we got fully republic. Until we were fully republic, there was no universal adult suffrage, and women being the last one, sadly the last ones to have the social rights or the political rights they deserve, definitely didn't get that in 1919. The chances are very extreme statement, and the backdrop, like imagine the year 1919 and they're getting all the rights, because not even like the entire population was not given right, and women, I think marginalized section, everybody was not having rights at that time. So India adopted the universal adult franchise in its full form after being the republic. Okay, that's the thing. And also just have an idea about Sri Lanka. Sri Lanka is one of the first countries in Asia to have universal adult franchise. So it's in 1931, based on I forgot what was that. Some constitution is mentioned that regarding this universal adult franchise. So just have an idea about that. Sri Lanka is the first country in Asia to have universal adult franchise, and so having this idea actually really helps, because Sri Lanka is the one to have that in 1931 and 1919 no. So this is not very common logic, but having an idea really helps. This is definitely wrong. It's an extreme statement, very unlikely. Government of India Act gave women reserved seats in legislature. It's true. It's one of the features of that act. 42B. So I think we are done with these questions. Few things to look for. Okay, 1909 Act, Morley Minto reforms. 1909 Act, Minto Morley. 1919 Montfort. Then 1935 Government of India Act, and then 1947 Indian Independence Act. Okay, these are the basic or the bedrock of India's colonial and later part of legislature. So this is a statutory thing, and you need to know about all of this. Yes, you will be studying this in history also. It's a overlapping position, so try to learn it when you're learning history. Okay, not in polity, but never skip this. 1909 Act, 1919, 1935, 1947. They are very important. Provisions will be directly asked. So learn about that. Before learning Charter Act, I recommend learning these, then go back to Charter Act, because these are more important. This is not explicitly relevant to polity, but I'm just saying because we are discussing such a question. So next. I took this question for a reason. Okay. N. Gopalswamy Iyengar committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reform and promoting it. In 1970, the Department of Personnel was constituted on the recommendation of Administrative Reforms Commission, and this was placed under the Prime Minister's charge. The issue with these questions is that this will be placed either in the first or in the last, and they are in between the polity is part of the questions, and people think that okay, they need to mark this answer right. This is an outlier question. You are not going to learn anything about it. This might have come in some current affairs, but it doesn't really matter. You can comfortably skip these questions. If you don't know what this means, you can comfortably skip these questions. Try using your logic, but there is a lot of risk to it, because there is a fact, there is given a person's name, then a lot of facts are given. So I recommend, if you come across questions like these and there is no room for elimination, because especially in this question you need to know about everything, or if multiple options are given, like 3 options are given and there is provision for elimination, then you may spend some time with that. Otherwise, don't go for it. If this is asked as only 1, only 2, only 3, again it's very risky. I am saying that don't be attending these sort of questions, because it's strictly factual. Nobody will be reading about these things. Maybe some sort of current affair mentioning some news might have happened, but don't spend time on these questions. That's why I took this question. You can right now you can feel the trend of polity. The kind of questions that are being asked in UPSC is actually very simple compared to the test series questions. They are very simple, but at the same time, people fail to clear these exam or clear even the polity part of the exam, because they overthink the test series and all. You might be having a cool head, or you might learn things beforehand, and you'll be having a clear memory about things. But when it comes to actual prelims, the questions will be on a level that is slightly on the easier side, but at the same time contrary to the norm, and ironically people were finding it difficult to clear it. So I'm telling you again and again, internalize things, go study in a structured way, and don't try to learn everything. Learn things and internalize it and think about things. So we will be doing that. Follow the series and you'll be able to fine tune your thought process with that. So I recommend you follow this. I can really help you with that. So that's one suggestion. And about this question, you should be skipping this. Okay, if you don't know the answer, you should be skipping this. I skipped this answer because I couldn't figure it out whether this name is right, or is it somebody else, or is it 1970, or is it directly placed under Prime Minister's charge. Maybe because DPOT, we know DOPT is directly under Prime Minister's charge right now, but was it like that before, or was it a different ministry? There is a lot of room for error. So the answer is different only. So I think the first one is wrong. Factually, first one is wrong. It's fact only. I don't know. Second is right. So the answer is B. Don't go behind questions like this. You can easily skip them. There will be one question, max 2 questions, something like this, and you can comfortably skip that. You won't be losing your clearing chances with that. Okay. What was the exact constitutional status of India on 26 January 1950? If you read a question like this just now, you will know the answer. There is no confusion to it. It's very easy. But at the same time, people have made it wrong. People who know preamble, who have read preamble, who know that article, like the 44th Amendment, First Amendment, Indian Independence Act, things like that are there. But the question is very plain and simple. The only thing you need to know about is 26 January 1950, meaning the country became a republic. Officially became a republic. We adopted the constitution, we enacted the constitution, and we became a republic. Okay, so obviously India will be a republic. Okay, that's mentioning everywhere. And we know the word secular is inserted to the preamble by the 42nd Amendment Act of 1976. So secular won't be the thing in 1950. It was added later. Not just secular. Sovereign, socialist, as in socialist, secular, and integrity. These are the 3 words inserted into the preamble with the 42nd Amendment Act. So this is wrong. This is wrong. A democratic republic, a sovereign democratic republic. Obviously, India is a sovereign democratic republic, because a democratic republic, India was a democratic republic. No, India wasn't. It was under colonial rule. So we became a republic, and we are a sovereign state, and we are democratic. So this is the answer. That's it. Takeaway: preamble. Learn about it. Read it multiple times. Look for keywords and solve questions. Preamble is very rewarding. It's a small portion. Just read it and have an idea about it, and it can really help you. Okay, so investing time on preamble is not a waste, but not at the cost of fundamental right, DPSP, fundamental duty. Okay, first prioritize fundamental right, then DPSP, then fundamental duty, then preamble. Start your polity preparation like this. I know this seems very unstructured, but this is how you should be starting, and this gives you a solid base to solve questions. Having idea about these can really help you solve most of the questions, and you will feel very confident. Otherwise, the issue is that the portions you are starting with, like Article 1 or citizenship, things like that will not be asked in most test series also. So you'll be disheartened, and in actual examination also their reward is very less. So stick to the fundamental, the basic and essential part first, then follow the other part. So that's it. I think that's about it for today. I'll be sharing this checklist in the group. You can follow that. I have structured it in such a way that you won't be once you are done with this, you are almost 80% covered. Of course, this is not exhaustive list. We cannot have an entire list like this. Then it will be syllabus only. But prioritizing things really matters. In this, which I have mentioned, doesn't mean that this is the one thing that should be read first. Just I am following the order of Lakshmikant. That's it. Other than that, this is not the case. Priority should be given to fundamental rights first, then DPSP, then preamble, then fundamental duty, then basic structure, and like that. Okay. I think everybody is clear with this today's portion. We'll be following the polity, covering last 5 years polity questions from 21 to 25. So follow, and I'll be sharing the resources in the channel itself. So that's it. Thank you.